and welcome to the Public Policy Perspectives on Felon Rights, presented by UCF's Office of Public Policy Events. The rights of individuals with felony convictions sit at the intersection of public safety, constitutional principles, community reintegration, and civic participation. In Florida alone, hundreds of thousands of individuals navigate the complex landscape of this rights restoration. They also navigate employment barriers, voting eligibility, and the social stigma following criminal convictions. Florida law addresses these issues through multiple statutory frameworks, including articles in the Constitution, specifically Florida Statute 940.058 concerning certificates of rehabilitation, and Florida Statute 112.011, which governs employment restrictions for those with criminal histories. Federal policies, including the Fair Chance Act and Second Chance Pell Grants, further shape the landscape. Today's forum brings together legal practitioners, correctional administrators, educators, researchers, and advocates to examine these policies from diverse professional and ideological perspectives. Our panelists hold different views on fundamental questions, what balance should look like in society, and how we can strike that accountability and that redemption. How do we weigh public safety concerns against barriers for reintegration? What role should correction systems play beyond punishment? And how should policy address documented disparities in who becomes justice involved? As required by Florida law, this event presents multiple perspectives on contested public policy issues. You'll hear viewpoints that may challenge your assumptions, regardless of where you currently stand on these issues. That intellectual diversity is what makes these discussions valuable for UCF, for our students, and for our community at large. I'm Irene Pons. I'm a senior lecturer and program coordinator for UCF's Department of Legal Studies, where I serve as a COIL mentor, which is collaborative online interdisciplinary international study abroad. As an experienced attorney and educator, I specialize in helping students connect legal theory to community practice. Let me introduce our distinguished panelists. First, we have Maria Pecoraro-McCorkle is an appellate attorney with significant experience in criminal appellate litigation, including Anders review and post-conviction relief. She also has prior experience working in the Florida legislature, which informs her perspectives in public policy and how they were developed with statutory interpretation. Her professional work addresses constitutional interpretation and the manner in which statutes, procedural rules, and appellate decisions collectively influence criminal justice policy. She's also a proud University of Central Florida class of 2008 alumna and an Order of Pegasus recipient. Lori Wurtzel Esquire is the owner and attorney for Wurtzel Law, PLLC, and the former vice mayor of the city of Maitland. With a background in criminal defense and post-conviction advocacy, she focuses on issues of rights restoration, community justice, and public service. Dr. Malik X is a major in the Security Operations Division of the Orange County Corrections Department and a senior level correctional administrator with over 25 years of public safety experience. He also serves as an adjunct professor and researcher focusing on first responders, well-being, mass incarceration, and incarcerated veterans. Michael Costas is the statewide coordinator for the Florida Coalition for High Education of Prisons, where he heads community outreach, volunteer training, and advocacy efforts to expand educational opportunities for incarcerated learners. He's an experienced organizer known for mobilizing teams and inspiring community engagement. Alex Lewis is a graduate research assistant and sociology PhD student at UCF. His research examines the stigmas of reintegration and justice of those that are impacted individuals and medications for opioid use disorder, bridging quantitative and qualitative methods to highlight structural barriers facing those with criminal justice involvement. Before we begin, I want to note that while some questions will be directed to specific panelists, based on their expertise, all panelists are welcome to offer additional comments or perspectives on any questions. Let's begin. Question number one, this is for all of our panelists. Florida currently requires individuals with felony convictions to complete all terms of their sentence, including full payment of restitution, fines, and fees. Before certain rights can be restored, from your professional perspective, what's the strongest argument either for or against this requirement?
I'll say, I'll say my voice, sorry, I apologize in advance, I lost it, but I sort of found it. I think that there's a lot of arguments against it, personally, particularly as to the financial aspect. So essentially, the arguments that were made was litigated at a high level in appellate court after that passed, and the idea is that that essentially sets up, discriminates on the basis of financial ability, right? And so there are some arguments to limit that just to restitution, for example, so that if victims are owed something, then maybe that would be treated differently, but right now the way it is it's restitution and court costs, and so that would be the main argument against that.
To provide a historical context to it, what we have in the Florida Constitution and what we have in our statutes is actually going to be a adaptation, if you will, of what we had incorporated from British common law. So under British common law, historically, once you committed a felony, you essentially suffered what was known as a civilius mortuus, which is the civil death. And not only could you no longer vote, but your heirs could no longer inherit from you. So that branch of your family tree was cut. And there was no way for you to ever regain any of your rights unless you were pardoned by the sovereign for it. When we had our Constitution and our Bill of Rights, some things you may have heard along the way, like there are no bills of attainder, for example, or there's no corruption of blood, those were not incorporated in our constitutional basis. And because the Florida Constitution builds its framework from the federal Constitution, we don't have those rights in there. So that's where the argument that, well, at least we didn't do everything that they did in the British common law. But to look at what it is from a jurisprudential aspect is that under Florida Statute 921-002-1B, the intent of the criminal statutes is punitive. The intent is to simply punish. Rehabilitation specifically says that it is subordinate to the intent of punishing for it. So when you look at Jones v. Governor, which was an 11th Circuit decision, that case said you can't tell me that because I can't pay my fines and fees that I'm not able to get my rights back. And the court came back and said, wealth is not a suspect class. This isn't a class like, say, sex. It's therefore subject only to the rational basis, which on your constitutional reviews is a fairly low standard of review that you have to go through for it. So when you're looking at it from why it remains in place and the arguments you may see having been litigated before, that case does explain why they are still largely in favor of having your fines and fees remain a prerequisite to regaining your rights.
Yeah, thank you for that question. And I like this question a lot because I think it highlights the flaws in our system when we talk about who is incarcerated in the first place. And a lot of the statistics show that most of the people who are incarcerated come from low-income communities. And so these communities don't really have high-quality educational programs, pathways to high-paying jobs. And so when somebody gets incarcerated, they're also expected to work while in prison. A lot of cases we're seeing that these people who are working inside the prisons are getting between 32 cents and $2 an hour, which is pretty unfair if you ask me. And according to a report by Edgeworth Economics, 7 states, including Florida, sometimes pay no wages at all for the majority of prison jobs. So what we're seeing is that we're expecting people who are coming from poor communities to, they get incarcerated, and before they can come back and participate in society, they have to pay their fines after making no money in prison. And the whole reason they went to prison in the first place was so that they could have money to survive on the streets that they're coming from. And I would just like to highlight a quote from Richard Nixon's policy chief, John Ehrlichman, and he says, the Nixon campaign in 1968 and the Nixon White House after that had two enemies, the anti-war left and black people. You understand what I'm saying? We knew we couldn't make it illegal to be either against the war or black, but by getting the public to associate the hippies with marijuana and blacks with heroin, and then criminalizing both heavily, we could disrupt those communities. We could arrest their leaders, raid their homes, break up their meetings, and vilify them night after night on the evening news. Did we know we were lying about the drugs? Of course we did. And I think it just has to be acknowledged that it's not as if the Nixon White House did this and then it all just went away. Like, this is how the system operates. It's the name of the game. This is a system for corporations to profitize off people who are incarcerated. And, I think overall, we can't expect those who are coming out of prison to be able to pay their fines and participate if they didn't have money to begin with and they're not getting paid well inside.
I'm going to approach this from a public safety process, and I'm going to talk a little bit about recidivism. And for the sake of this conversation, recidivism deals with anyone that's returned to custody within 3 years. So a recent report by the Florida Department of Corrections out of 2019 supports that 21% of those that are released from prison return back to prison. So when we have blanket policies, such as requiring felons to pay all fines and complete all their sanctions prior to retaining some of their rights again, it just contributes to that mass incarceration. Right now in the United States, on any given day, there's approximately 2 million people that are in some type of state custody. That custody is a result of various things, but when you look at it from a larger lens on that, most of the people that are in these jails and these prisons and tribal jails and things of that nature are from economic communities where they may not have the resources already. And by making them or requiring them to pay and complete restitutions on these various other programs, put them in a position to where they're not able to succeed. The second part of that for me, I want to talk about disenfranchisement. That is also a process, and even though we have the Amendment 4 that was passed in 2018, again, without paying some of those court costs and things of that nature, it's very difficult for them to retain some of those rights. Now, I want to be clear, I'm not suggesting that because you are released from jail or prison that you have no responsibility or accountability. I do believe that, but I believe there has to be a holistic, tiered approach and what that looks like. We've all seen in the past where we commit or we approve legislation that somehow it sounds good on the front end in theory, but it has unintended consequences. And as a result of that, we contribute to that mass incarceration. For example, in 1994, the Violent Crime Control and Law Enforcement Act was passed, and everyone touted that as the get tough on crime approach, and that was supposed to put an additional 100,000 officers on the street. It allocated billions to building prisons and other financial incentives, but the unintended consequence of that was mass incarceration. So again, I think we have to be very careful when we put policies in place. And I understand the design of them, but we have to be careful because they have unintended consequences. And last with that, policy implication for me again, I would recommend or I would support a tiered approach versus a one-size-fits-all approach. Because working in the field for the last 27 years, a one-size approach does not fit our current population, and it surely won't fit them when they're released.
I actually don't have too much to add. Excellent points from everybody. I would like to mention, this is kind of a dated statistic, but in 2016, 1 in 5 voting age Black people in Florida had a felony conviction and could not vote. As far as rights restoration, class, I suppose, can be discriminated against, as was mentioned previously, but there is something seriously wrong if 1 in 5 people of voting age of a race or ethnicity cannot vote. And also, the country was founded on taxation without representation, and that's kind of felons pay taxes, felons work. They should be represented, they should be able to vote. That's all.
The point about the recidivism rate is actually provides an opportunity to give you an example of the intersection of public policy and the power that the legislature has, the 3 branches of government for it. Under 787-084, we have a bunch of recidivism statutes. These are known as your prison releasee, reoffender, habitual felony offender, habitual violent felony offender, and violent felony offender of special concern. All of those, well, for example, for the PRR, you have to, if you're released from prison and you commit certain enumerated offenses within 3 years from your last release from probation or the Department of Corrections, your statutory maximum can be increased. So for example, in Florida, if you are convicted of a third-degree felony, your statutory maximum is 5 years. The PRR increases that. If you are considered to be a habitual felony offender, you will then have to serve a certain amount of time. And I may have PR and HFO backwards, but with the recidivism rates, with those type of recidivism rates, you are seeing a lot of cases in which people are qualifying for longer periods of time in prison with mandatory. So there is gain time that you get essentially in the state of Florida. It's about 85% you need to serve your sentence. These will not allow it. If you've ever heard of like the 10-20 life law that we have in Florida for firearms, those are day for day. So if you commit a second-degree felony, but you discharge a firearm resulting in death or great bodily harm, and you've been released from prison in the last 3 years, instead of facing maybe 15 years in prison, you're facing up to life in prison. So it's very quick under our statutes to very much escalate what your exposure is to mandatory time in prison. And the reason I bring that up is because it is so much what we have with the constitutional basis of due process and voting rights, but then we have to look at where the legislative side comes in and what they're permitted to do in sort of setting the public policy for repeat offenders, and how that very quickly does escalate into those mass incarcerations for decades, if not lifetimes.
Thank you. This next question is for Maria. And it's Florida's Constitution and implementing statutes create a specific framework for rights restoration. From your appellate and constitutional law perspective, what are the key legal considerations, whether equal protection, due process, or others, that either support or challenge conditioning rights restoration on financial obligations?
That sounds like a bar exam question. Essentially, when you look at all of those things that we think about, there are a couple of constitutional provisions that are in tension with each other. One of them that I think is not widely discussed, but I think that conversation will be coming soon, is going to be the question of the Eighth Amendment. So the Eighth Amendment is the prohibition against cruel and unusual punishments, and there has been a softening, if you will, in the jurisprudence. We now see that minors, or those who commit even heinous offenses before the age of 18, cannot be sentenced to death. For example, we had that first case that came down and affected a ton of our juvenile cases and actually required under 921 to build an entire new statutory framework for sentencing minors to life in prison. Just to give you that little update, you could be sentenced to prison and that would be the end of it for you at 20. Now, there's a minimum review at 25 years for you to be able to see if you have rehabilitated, that you can be released from society, because the idea is that you're not a full adult at 17 if you commit an offense. 25 years in prison, we'll see what happens. And that's how that statutory framework came in because of the United States Supreme Court's decision about the Eighth Amendment. So when you're looking at the Eighth Amendment, we have evolving standards of decency, which comes into play, and then you have a proportionality analysis. Can a felon, if I complete my 5 years in prison and I do pay my $25,000, $30,000 in fines, is it a violation of the Eighth Amendment for me to retain the felon status, for it to stay with me for life? Is that civilly or mortuous that I mentioned earlier? Is that cruel and unusual to require that? But then on the other side of that, you have to look at what the states have in terms of their ability to govern themselves and to determine what is going to be an appropriate punishment, how they can determine what their electorate is. We see even outside of this context with voting rights in general, the tension amongst the states and the federal government about who can vote even if there's not a felony conviction involved. So when we're looking at those rights, we have to go back and look at the underlying constitutional provisions, and then we have to figure out as a country really, what is going to be the balance between what our federal rights are, what we have in that Constitution, versus what we as the residents of Florida can do as citizens, and what we're going to allow our legislature to say in terms of the policy. It's a long-winded answer to say it depends.
Does anybody else want to add anything to that one? All right, Lori, this next question is for you. As both a criminal defense attorney and elected official, You see both legal processes and governance. So where do you see the most significant disconnect between what the current law requires and what serves either public safety or successful reintegration? And what specific legislative change would you propose or oppose?
So a lot of what I know about those things, because working in the city, or I was working in the city of Maitland, which is really tiny, and we weren't dealing with voting rights usually. But I am a member of the Florida Association of Criminal Defense Lawyers, and I'm the chair of their legislative committee's lobby days. So we go up, we just went to Tallahassee to talk about legislation, and this session there were 4 bills that addressed voting rights, essentially 2 different ideas. There's always a Senate and a House version. They're both dead bills this time, but the rule of thumb is what, 3 times, right? so that's good. And one is from Bracy Davis, which is one of our local representatives here, or local legislators. But essentially, I think to some point, sometimes it is unintended consequences of legislation. You see that a lot. That's a lot of what we try to address in Tallahassee. Just like I always say to the legislators, just like a farmer comes to explain, hey, you didn't realize that this really good thing you're doing, it affects all of the soybean farmers, or what have you. Because those generally are very unintended consequences. I think sometimes we have that with these issues, and sometimes I believe that they are intended consequences, frankly. The history of these laws, I wrote an article in 2020, and I was looking through it because I'm not nearly as good as you with the numbers, which is why I gave a tiny side of statute, and admiration, truly. But in 2020, I wrote an article about voting rights restoration, and got into the history, and I learned for that article. And at that time, I think 2018 was also the statistic that 2.5% of the voting eligible population as a whole in the United States was ineligible due to a felony conviction, but 25% of those are in Florida. And one of the primary reasons for that is Florida is unusual. Usually we're along with Texas when it comes to criminal justice issues, and we're special in what I would consider a bad way on those issues, in the sense that most states in the United States do allow convicted felons, or what we would call returning citizens, to vote. So the most progressive states allow individuals to vote from prison, which is obviously one extreme on that continuum. And many others have laws similar to Florida's. So this is not normal. And it does come from Reconstruction Acts and things like that, when traditional voting, determining who can vote and under what conditions, is generally reserved for the states, which is why we can have such different rules everywhere. And everyone knows enough about American history probably to know that there was a time when states in the South traditionally had to get on board, right, with allowing, at the time, of course, only Black men to vote, right? And so when that happened, states found other ways to accomplish the same purpose, and this is really one of them, okay? So all of that being said, I mentioned earlier that from my perspective it is unfair to make the determining quality of voting whether or not you can pay something, basically. And so there was a compromise that came out of that litigation, because there were constitutional arguments made about that. So the compromise that ultimately came out of the legislative compromise really is that there is a way around that. If I can't afford to pay my court costs, then I can petition the court, the sentencing court, so it'd be like this wherever, Orange County Circuit Court or whatever. And there's a whole procedure I won't bore you with. And so I've been doing that as a volunteer for the Florida Rights Restoration Coalition for several years now. And what I find that these bills that were introduced in session this time, I think help to address, is that there's a few different problems. One, people don't always know. Right? We're in a room, not just us here, you, by virtue of being in this room, are highly engaged and have the privilege of education that not everyone does, right? And so there's that alone. So one of the bills was simply to put on a score sheet, which is something that everybody should theoretically see if they're going to be a convicted felon in a courtroom, just a little, basically like a notice. Just so you know, FYI, here's this rule and this is what it means. That's one. That would be, from my perspective, extremely easy to implement. From my perspective, there's no reason not to do that. No good reason. The second one is a little more complicated, but I think addresses a bigger problem, which is how do I know, what if I want to pay my court costs? And I can pay my court costs, but I don't know if I have them or where they are. There is no way to know. So when I help someone who comes to me through the volunteer work I explained, and to basically explain to them if they are eligible or like that, what I have to do is rely on them to tell me where they have felony convictions, what counties, and then to look them up individually. There is no central database. There's no central database for the citizens. There's no central database for law enforcement. There's no central database for the supervisor of elections. And right after these laws passed and were resolved, there were several people that were prosecuted for illegally voting who believed, according to them, that they did not realize that they did not qualify. And they were prosecuted. I would argue that that was a concerted effort to scare people out of using the right to vote. I meet people all the time who think that they're convicted felons and are not, by the way. And there's a lot of reasons why that can happen in Florida. Or who didn't realize that they had a case in Alachua County or what have you. So the other bill would create a centralized database that anyone had access to. Again, theoretically, you could argue that that would help the government to cut down on any fraud that did exist, because it would be a very clear-cut way to determine who was eligible. I do think that, in fairness, that would be a fairly complex task, an expensive administrative task in the government, and so it's probably going to be a little more of a challenge legislatively, but I do think that in theory that's an excellent idea as well.
Thank you. Dr. Malik, with a question for you. With over 25 years of corrections and research on mass incarceration, you've seen how policy translates to practice inside facilities. What does the evidence tell us about how rights restoration policies impact rehabilitation, recidivism rates, and successful reentry? And the second part of the question is, should correctional philosophy inform these policies differently than it currently does?
Thank you. So I'm going to approach it just from a data standpoint initially. I'm going to approach it from a data standpoint initially, and I'm going to give you some data points. In the United States currently right now, these statistics are from 2025, and they're provided by the Prison Policy Initiative on Mass Incarceration. So right now we have a total of 1,566 prisons here locally. Federal prisons, BOP, is 98 facilities, local jails, 3,116. And I share some of those numbers with you as it relates to mass incarceration. So unfortunately, at times, we have the distinction of being one of the largest per capita mass incarcerations nations of in the civilized world, so to speak. And what that means for me being firsthand and having an opportunity to work in the system is that oftentimes when I go to work on a daily basis, I can see what this mass incarceration looks like and what it contributes to. So as a result of that, for me, as it drives the policies, can you guys hear me okay? Thank you. Okay, sorry about that. My voice is kind of low this morning, but I do apologize. I want to make sure I speak a little louder. So for mass incarceration, as you look at it across the board, in the state of Florida, you can go to jail for pretty much anything. And there was a popular song that one of my nephews shared with me, and I'll just use this little excerpt of it just to kind of help understand what I'm trying to say. So it says, come to Florida on vacation, leave on probation, and then be extradited back for a violation. Okay? So when you think about that from a larger lens of that, it just simply means that mass incarceration is something that's real. It is something that I see and deal with on a daily basis. And part of that process is that the policies that we have in place, and again, I understand why we have the policies and rules and laws in place, but back into custody at a higher rate. So the second thing I'll talk about a little bit about is recidivism and how that drives our policies as well. So I mentioned earlier that recidivism is basically if you reoffend and rearrested and brought back to prison within that 3-year standpoint. So just a number to share with you. On average, we have about 24,000 people that are released annually from jails and prisons within our area. And as part of that process I shared earlier, 21% of those are then rearrested and brought back into custody. Part of that is for criminal violations, but the second part of that is what we're talking about here today. Some of that deals with fines, technical violations, and because for whatever reasons they're not able to pay those fines or complete these processes, they're generally brought back into custody, and it starts that whole circle all over again. And when you look at the unemployment rate, again, working inside the facility, I see firsthand our inmate population. I interact with them firsthand, and I'll submit to you that it's oftentimes that when you're dealing with adult males, adult females, or in some instances juveniles, the educational attainment is part of the reason why they're back in jails and in prisons, because they don't have the means or the educational attainment to obtain meaningful employment, which also further contributes to them not being able to pay the restitution costs. So when you look at it again from a holistic standpoint, it is a circle, it is a vicious circle. Reading an article prior to me coming here today, I read about a gentleman down in South Florida who had been arrested 344 times. 344 times. And as I did a little more research just to kind of review that, the bulk of his charges were just small charges, petty charges, panhandling, and things of that nature. So what that suggests to me is one or two things. Either he loves jail or prison, or again, he doesn't have the resources or the educational attainment to find meaningful work. So he panhandles and does things of that nature. Now, I'm not justifying his actions by no means. What I'm simply sharing is the reality of those individuals that I see. I've seen gentlemen that I've supervised in juvenile detention center, and as they graduate and work their way into the adult facilities. So again, it is a process. So for me, policy does dictate and contribute to mass incarceration. What is the answer? Again, that is unknown. Again, each state moves and does things a little bit differently, but looking at the picture again from a larger lens, if our policies remain and continue to stay where they're at, then we'll continue to have that same problem. And from a policy standpoint, my recommendation or my ideas would simply be to evaluate our policies based on our current times and focus more on rehabilitation than incarceration.
Thank you so much. This question is for Michael. As statewide coordinator for the Florida Coalition for Higher Education in Prison, you work directly on expanding educational access. How do current policies regarding felony convictions, both during incarceration and after release, affect educational opportunity? And what systematic changes would most effectively support educational pathways for justice-involved individuals?
Thank you for that question. One of the policies that really does affect those that are incarcerated who want to seek an education is the residency requirement. And what that means is that if somebody is incarcerated and they can't physically prove that they're a Florida resident, they have to pay out-of-state tuition. And as I addressed earlier, they're probably coming from a low-income community, and to pay out-of-state tuition in Florida is incredibly expensive. And that really pushes folks inside away from wanting to pursue an education. And we also see that there are specific rules and regulations for what colleges can offer versus what universities can offer. So the university system cannot offer college degrees, we can offer certificates, which we hope will be able to facilitate a smooth process for somebody who is released to get into a university system and start taking college classes. And we also see that getting released, re-entering into society following incarceration is an incredibly difficult task. And there are so many hurdles, barriers, obstacles that exist that make it incredibly difficult for folks to know where they're going. And so, when it comes to the policy changes that would most effectively support these, solutions, hopefully we can get colleges and universities to participate and start offering degrees as a whole for folks that are incarcerated at a reduced cost. So that way, when somebody is released, they can have an educational background that can prove to the folks outside that they have the dedication and desire to make changes in their lives. And beyond that, you know, fostering a system that harnesses the potential of reentry organizations and mental health organizations to work in conjunction with educational organizations and groups. And so what my goal is with FCHEP, the Florida Coalition for Higher Education in Prison, is to kind of create some sort of, smooth process that allows us to utilize the mental health resources from small nonprofits, whether they're in Miami or in Gainesville, and hopefully as a coalition we can help them expand their staff, their notoriety, and bring their resources to the different parts of the state where they do not currently exist, and tie that into the broader reentry network that exists, where a lot of these groups work independently as nonprofits and don't often rely on each other to, create that network of balance. And so, as we've seen over the past few years with my work at FCHEP, there's a lot of desire to start working with others, but one, they don't have the time or the funds, and they're worried about losing their funding, and they also don't know each other exist. And so as we've developed this coalition, there's been a lot of different groups that are really grateful to see the different areas of the state that are advocating for the policies and the changes that we want to see happen, and we're hoping that they can rely on each other so that when somebody is released, they'll have a stronger sense of who they are and a healthier mind. They'll know where to go to get a job, and those organizations will be able to provide them with exactly what they need, and they'll have an education to show that employer what they're capable of doing. And when I was a student at UCF, one of the things I did when I was in the Senate was pass a bill called Unlocking Higher Education. And so there's a movement called Ban the Box, and what this is it would remove the question of asking if somebody has been formally incarcerated or convicted of a crime. And at first, people may be weary of removing that question, but when it comes to the admissions team, there's a thorough background check where the admissions team will know if somebody has been incarcerated, and they can do their background check on their own. But when you have that question up there, it discourages folks from wanting to actually even apply to the university in the first place. And beyond that, bringing technology into the prisons in a way that disincentivizes corporate profit, but maximizes the individual potential. So that way they are able to understand what AI is and how it will affect them upon release and what it means for the broader society. What it means to have two-step verification and that you need apps to do literally everything in your daily life, and the importance of having a cell phone and how to use it. Beyond that, all these things are very expensive, and so we're really talking about so many different, issues to address. But I think that would be, how we can make reentry a more smooth process for those that are getting released.
Thank you, Michael. Our next question is for Alex. Your research examines stigma and reintegration of justice-impacted individuals. Can you speak to how employment restrictions, housing barriers, and disenfranchisement create or perpetuate structural disadvantages? What does the evidence suggest about the relationship between rights restrictions and successful reintegration?
Thanks so much for the question. So I think that I'm in kind of a unique position to answer this. So I actually have a felony. I got a possession of heroin charge when I was 21. I was not convicted. I was, as was previously mentioned, one of those kind of like nebulous, like felony status situations. So I received an adjudication with hell, which means I believe that I am not a convicted felon in Florida, maybe other places. But I was charged, and typically the way that those like ban the box questions are worded is where you charge rather than convicted. Some of them are convicted. So I can tell you a little bit about my experience with employment and housing and education, and then I'll tell you what the research says. So I have never had a job that somebody didn't give me as a favor. Like, I was 21, I had never had a job. The only thing that I had done was like sold drugs or do other things to get drugs and make money. So I didn't have like an official like employment history. So when I graduated the rehab that I was court ordered to, they gave me a job at the rehab because I told them, I am going to go to prison if you don't do this. I was on, I had a 4-year suspended sentence, which was if I messed up during my probation, I would go to prison for 4 years. So they said, okay, we'll hire you. They hired me. I ended up going to Valencia. I met my ex-partner now on Tinder. And so I had like a lot of these friends that were heroin addicts, obviously. I met this guy and he had this like really robust social network that I suddenly could like get into. So now my friends don't do drugs anymore. My partner convinced me to go to school. I tried school, I realized I was really good at it. That's too my I mean, I started using heroin when I was 16. So like I graduated high school with like a 2.1. I didn't think that I was good at school. But I went to Valencia, I did really good, I got a 3.8, and when I went to apply to UCF with the Direct Connect program, I had to jump through like a ton of hoops. They asked me for like court records, and like I didn't know what I was looking at. Like I screenshotted everything and sent it to them. I like didn't know if I had the right thing. I think that I gave them the wrong thing first, and they were like, this isn't the right thing, and I just said, okay, we'll take all of it. And then I did a panel interview where it didn't seem like they were used to talking to people that had done something a while ago. At that point I had like, it had been 4 years, I was done with probation. And the questions that they were asking me did not make a whole lot of sense. So they ended up recommending me for admission on indefinite academic probation for using heroin and getting caught 4 years ago. That, as Mike was mentioning, really signaled to me that like higher education didn't want me here. Like I wasn't in position. And I tried to apply to get that taken off, and I was denied like twice in a row. And I still couldn't tell you why. I answered the questions they asked. And there really wasn't anything for me to say other than like, yeah, I don't do heroin anymore, and like I'm doing school, and like, you know, I've gotten 2 B's at this point. I had all A's. Like you would know if I was on heroin. Like, anyway, so that was my experience with education. And then when I applied to grad school, all the grad schools ask if you've ever been convicted of a felony or charged or whatever. So when I was applying out of state, like all of that passed, and it really like restricted my options because I had already gotten into UCF. They already knew me, they already knew that I was cool to come here. It made applying to UCF and accepting a PhD offer at UCF a lot more safe, I guess, that like, I at least wasn't going to get kicked out for having a felony here. So that's my experience with employment and education. As far as housing, like I was very fortunate that when I moved out of my parents' house, thankfully I had supportive parents. I moved out, I moved in with my partner. I was not allowed to be on the lease. The apartment complex would not rent to me. Thankfully, my probation officer also was cool, and I told him, like, hey, I'm not on the lease, please don't mention I live here to anybody. And he was like, oh yeah, I don't care, like, that's fine. So like the whole time, I thankfully, after that apartment complex, found like a private landlord that like didn't run a background check and didn't ask. So that was cool, but like having to find housing, employment, education as somebody with not even a real felony is like, it sucks. And I'll tell you what the possession of heroin was. It was 2 empty bags with residue on it. Like it was $20 worth of heroin that I bought and did. I wasn't manufacturing it, I wasn't distributing it. Yeah. So as far as what the research says, there's a lot of theories. So there's like life course theory in criminology, which says that like as people age, they are more likely to desist or stop committing crime. And there's things like getting a good job and getting married that are associated with not doing those things. But those are just kind of proxies though, right? Like just because you get married doesn't mean that you'll stop doing crime. Like the marriage it signifies something. There's some kind of change that's going on. Or getting a good job. There's a reason that you stop doing crime. As well as like differential association theory, like the people that are around you tend to, like, it's a reciprocal relationship of you shape how they act and they shape how you act. So all of this is to say that by concentrating people with felonies in the areas that will rent to them and the jobs that will hire them, you are concentrating this like disadvantage, and it's called like criminogenic effects, where if somebody is doing crime and then you are maybe like more likely to do it because you're around it. As far as kind of lost my train of thought there. I think that's all I have to say. Thanks.
All right, we have one closing final question. This is for all of our panelists. How do collateral consequences like voting restrictions, employment barriers, or limitations on certain licenses shape long-term reintegration, and what level of weight should these consequences carry in Florida's broader sentencing and rights restoration framework?
I just want to say as to that, obviously, or maybe not obviously, I think most people would agree that not all collateral consequences or rights should be treated equally in this conversation. For example, I don't personally believe that voting rights restoration or professional licensing should necessarily be considered the same as firearm rights, for example, because there's at least a more obvious, if not statistical, correlation between some of those things in public safety. But while Maria is absolutely right that it is in our statute, or in our Constitution, the purpose of the criminal justice system in Florida is punishment. It doesn't mean that we have to agree with that as a point of efficacy. And I genuinely believe that while legislation can accomplish so much and is obviously a very important tool in these conversations, that I do think public education on these issues, like being right here, is really important. I think there's a lot of misinformation, just based on assumptions and like cultural things that color and shade how we think as a society about these issues. Sometimes things aren't fair, right? Like higher education in prisons is statistically pretty well supported in terms of its effects on recidivism, but it's not fair, right? Like if I'm a student and I don't have a felony conviction and I can't get a free college education, I might have a problem with someone being able to do that in prison. But there's a lot of things on the other side that aren't fair either. And so we are, as a society, very focused on fairness, and in general, I think that's a good thing. But I think sometimes it is an impediment to our advancement as a society as well. As was already said, if we continue to do the same things over and over again, we will likely have the same results. And there is a huge power to human dignity. There are other people on this panel who have more of an ability to speak on statistics of that, although I know that they exist. But I see it in real life, in my personal life and in my professional life, of how we treat people, how we talk about them. I love the stories about what you see on an application matters to how people behave. So even if you don't care, even if you're not the bleeding heart impact that I am, or you're speaking to someone who that just isn't powerful or persuasive with, there are very real statistics. I tell people all the time, it's almost like a catchphrase, I feel like our obsession as a society with punishment and justice in that context keeps us less safe. And I genuinely believe that. for a variety of reasons that have been discussed and not today. Because as I used to teach high school criminal justice, and so sometimes I pitch things at a K through 12 level, but if you take people who were already struggling for some reason, in a way that got them to prison, there was something, whether it was mental illness, poverty, drug addiction, all of the above. And you put them in an environment that's not conducive currently to positive change for most. And then you're released into a situation that you've already heard is incredibly more difficult in terms of getting a job, getting housing, and all of those things. And you don't have the comfort of a family or a support network. How would we expect you to do better? It doesn't make logical sense. And so I genuinely believe there needs to be an overall cultural shift of our hearts, essentially, and our mindset about things before we can really change.
As to the question of licenses, section 112.011, because I like my statutes and I like my case. I have my citations if you're interested, I do have them. What the statute says, and this is actually going to say that this is not just a state level public policy issue, but this goes down to your municipalities as well, as the statute says, a conviction cannot bar you from getting a license. And that sounds great until it says unless it's a felony or a first degree misdemeanor. It's everything. There's a lot more felonies in the criminal statutes and a lot of first degree misdemeanors. And see, when you have your misdemeanors, if you get more than one, they eventually add up and become felonies, like theft or larceny offenses. You get one, you get two, all of a sudden you're now in a repeat larceny theft, and now you have a felony on you, even if you've been alleged to have taken something of just a minor value, for example. The reason why that statute shows what we have going on at a deeper level is because that is a state statute. That is what your state representative and your state senator vote on to enact. But the other provisions of that statute also state that municipalities and county governments, so your closest level of government to you, are allowed to have restrictions and completely prohibit you from being able to take certain positions, certain occupations, if the felony, if it basically is a public safety and the felony that they don't want you to have is reasonably related to that job. And when you think about what attorneys do, we love adverbs because we can drive Mack trucks through them. If you give me something that like an adjective or an adverb, there's a way that they can argue why this does or does not apply, hence it depends all the time for it. The reason why that matters is that this isn't just what's happening at your state level, this is also what's happening at the decisions of your county governments, this is what's happening in your municipalities for it, and you have to understand that when it comes to that, you have to be able to have those conversations about licensures and having that reintegration. But on the flip side of that, when you look at what the United States Supreme Court says, so the buck stops with them, those collateral consequences, even if they're severe and could be tantamount to a punishment, they still it really isn't their issue to worry about. And the reason I say that is because think about deportation issues. You have to be advised that you could be deported for it, but it's not held to the same level of incarceration. So we have not only that tension about what is a collateral consequence, what isn't, we also have statutes, and then we have additional decision-making on how to acknowledge those statutes, right in the very people who determine who our water rates are going to be, who are going to hire people to work at our landfills, who are going to work at our libraries. And that's another example of the public policy just being everywhere and not just in a statute book in Tallahassee.
I'll dovetail on what's already been said. I'll start at a different level. In my position, I get to see people at their worst. And what I mean by that is the very first time they enter the facility, that picture is taken and the handcuffs come off. But there was one part of my career where I got to see people at their best, and that was when we were doing releases. And this relates to that employment piece. I worked at the work release center that used to be on Cayley many moons ago before, of course, we shut it down. And we had low custody offenders that were transferred there from our facility. And part of my job as the facility administrator was to establish new jobs and new employers that were willing to hire my work release inmates at the time. And so kind of dovetailing on what's been said already, I had the opportunity to go out into communities, and it was a very difficult sell trying to explain to an employer why they should give someone a second chance. Now, I'll take it back a little bit further. I don't want to date myself because this is being recorded, but I can remember a time when we did things and they called it joyriding. I can remember a time when we did things in pep rallies and it was just kids having fun. I also remember going to high school and there wasn't an SRO, which is a school resources officer in the schools. So I say that to say this, things are different now. And to my original point, it is easy to go to jail or get arrested, as mentioned here, and it's even harder to convince someone to give you a second opportunity when you have that stigma of having a felony. I know on TVs and various TV shows they glorify a badge of going to jail as a glorification, but I can tell you in the real world, when reality hits and it's time to pay that restitution, or when it's time to come back and see that probation officer or pay for the cost of supervision, and you don't have the skill set, it's very difficult to do so. So I was successful in my position as a work release. Most of the jobs I was able to obtain were either in the restaurant industry or manual, meaning working outside in the hot floor in the sun. And the good part about that was I was able to give them employment to pay their restitution so they complete their financial obligations to the courts as well as the victims. But the downfall was every time that I released one of them, they would immediately quit the job, so that employer was hesitant about rehiring the next person that I bring down there. But I can tell you, in more cases than not, within 30, 60, or 90 days of getting back, some of the people that I released called me back and said, hey, is that job still available? Because they found the difficulty to find a real job. So again, to look at policy from a larger lens, and again, I know what the policy was for, I know they're meant for overall betterment of society. In layman's terms, they want everyone to play by the rules, but again, some of the unintended consequences of playing by the rules and following those policies to the letter of the law results in that phenomenon we call the prison industry complex or mass incarceration. Do you mind repeating the question?
The question is, how do collateral consequences like voting restrictions, employment barriers, or limitations on certain licenses shape long-term reintegration, and what level of weight should these consequences carry in Florida's broader sentencing and rights restoration framework?
Yeah. I mean, I think everybody around me has really done a phenomenal job of addressing this question. I think it's just important to acknowledge the barriers that we've discussed today and how they affect somebody's release and the hurdles that they have to go through as they are getting back into society. And so, it is my hope that as we have these discussions, we can address the different systemic issues that create a system not meant to rehabilitate, but meant to incarcerate. And that as we continue to push the needle, we will see there are a lot of folks inside who would actually appreciate these opportunities to make a name for themselves, to support their families, to support their loved ones, and to be productive in society. And so, that's what I have to say on that. But thank you.
Great question. The felon label is so impactful that I got my train of thought back from earlier. The research shows that because of the difficulty finding a full-time job with a felony, people end up with part-time jobs. They don't have health insurance typically or benefits, and this kind of creates a second-class citizen where they're working multiple part-time jobs. They live all in the same area. They deal with a lot of the same risks associated with that. And one argument is that the Affordable Care Act exists and there is health insurance that is available. Not everybody takes it, and it's not the same as just automatically getting signed up through your job at a 40-hour-a-week full-time with benefits type thing. And the label of felon is so impactful when you look at the impact on like health, employment, et cetera, of the felon label, it is almost preferable, or I mean, it definitely is preferable to just like do away with the label altogether, because it is so difficult to get out from under that, and it impacts so much of like everyday life for somebody with a felony that it just, the impact is just like so great, it cannot be overstated.
We'd like to take questions at this time, so thank you so much, panelists, for your input, your feedback, and your expertise in these areas. When called upon, if you have a question, please come up and be concise. We ask that you pose questions rather than make statements, and that your questions allow the panelists to share their expertise and perspectives. Who has the first question?
Good afternoon, members and guests. My question was, when you were speaking, I'm sorry, what's your name? Yes, sir. Malik? Yes. Sorry. Thank you, sir. Malik, you were speaking about recidivism and how you were helping take some of the more progressive steps to minimize that for people who had experienced incarceration, post-incarceration, had now been tainted with a felony. Now you talked about creating employment opportunities and helping now secure the means to pay for these fines. Now I wanted to ask, how long did it take to pay for these fines? Because now, you know, when you have a felony, which was mentioned, you're basically outcast from every aspect of society, including, you fall into this category of having to deal with an immense amount of wage disparity. So, you know, when you're trying to work your way back into a mainstream society, it is very hard if you don't have the means to do so. So, you know, these jobs that you mentioned, which were hard labor jobs, hospitality, landscaping, and these people, obviously, they just kind of fell out with the whole process. Like I said, how long did it take for these people to secure the means to pay for those fines? Was it a long-term thing or was it short-term?
Great question. Most of the time, unfortunately, it did take a while. The facility that I was at, although we afforded them finding jobs, the rent and subsistence, we called it, was very minimal. So we only charged them $50 a week to be a resident there, and any additional monies that they made, we deposited that, paid their court costs and court fines, and upon release, we wrote them a check for the remainder in there. So for me, it was great when a person got out of jail after 52 weeks, and we were writing them a check for say $12,000 or $13,000. We call that a new outlook on life. When you can walk out of jail with that kind of money. Now that was sometimes a little bit difficult, and for the ones that had that much, those were the ones that went out and they took full advantage of what we had to offer. But just like anything else, we had individuals who didn't want to work, or who never tried to seek meaningful work. They would just do enough not to be transferred and put back in jail for failing to comply with the rules. But at the end of the day, as you mentioned, it is a long process. Those jobs were, most of the jobs, as I mentioned, were hospitality. They were washing dishes at a restaurant, cutting grass, landscaping, things that didn't pay a whole lot. It was an honest living, but it didn't pay a whole lot. So after you pay your court costs, your restitution, any of the civil fines you may have, and then your $50 a week subsistence fee, sometimes there may not be a whole lot left over. So what I had myself do was one of some of the cases where we just reaffirm them and remind them that although you paid all this money, and although you may not have money left in your pocket right now, you're free. You're not in a secure confines. Although you're still up under custody being supervised, you're free. And that freedom is priceless.
I don't know if anyone in this room has student loans by any chance or credit card debt ever in your life, but it's similar. If you can't pay, I mean, obviously, I was a public defender, and so my observations of that work versus in private practice are quite different. A lot of my clients now can afford to pay for my services, so they're paying, you know, with a check for the full amount. But if you can't do that, there are various programs like collections court and things like that. They add essentially interest, but it's theoretically worse than interest because it's a flat fee each month. And so that is part of why all these like add up, or it's much harder, or takes a much longer time to pay it off. And then ultimately they'll get referred to collections, like a collections agency, literally just like you're used to. And so the clerk is selling off those debts basically. So it's a business.
I have a question. A lot of the conversation has focused on rights and things outside once we have the returning citizens as far as like the applications and housing and employment. When it comes to those who are currently incarcerated, what rights do they have? We didn't really touch on that.
So that's a very interesting question, because once you are within the custody of the Department of Corrections, you essentially become the ward of the state. So even your communications, you lose your rights entirely in the sense that statutorily, and I'm not going to cite statutes, I can't remember it for once, but for example, if you go on probation, for example, you don't have the full Fourth Amendment right that you have a right to unreasonable search and seizure at any time. You can be searched, and it doesn't have to have a warrant for it, for example. There are additional regulations that you're subject to in DOC, whether you are in the jail, for example, so like a first-degree misdemeanor, you can be held in a county jail for 364 days. Even if you are in the juvenile delinquency program board, if you're in a moderate risk facility, if you're in secure detention, you don't have the ability to really make decisions for what you want to do with your autonomy for it, the way that if you are trying to reestablish your rights, that's where we come into the habeas corpus land and your Rule 3850s, and that's where we see you basically file a motion to the court in which you were adjudicated guilty, and you allege that you are unlawfully detained because there was an error with your proceeding that led to your conviction for it. This is one of the things that is a right that prisoners do have. This has been affirmed at the state and federal level, that you do have a right to, you don't lose your right of access to the courts. Now, the access to the courts is specifically enshrined in the Florida Constitution. It is not enshrined in the federal Constitution, so it's specifically a state right. And that's important when we were talking about like the Eighth Amendment, which is the federal versus our right to courts in Florida. The reason why that matters is because that's where we see a lot of filings are going to be pro se prisoners who are going to file the petition for the writ of habeas corpus. It's one of my favorite writs because it stands for show the body, bring forth the body. And it's the idea that if you believe the governmental entity is detaining you in prison because your conviction is invalid, you have the right to at any time say, I'm illegally detained. Now, if you're going to make the allegation that but for my defense counsel's actions, for example, I would be in prison, that brings you into the Rule 3s of the Florida criminal procedure for it. So the long-winded answer is that when it comes to the rights, in terms of your daily life, those are essentially gone, and the idea behind the theory behind it is that you have broken the social contract. And by breaking the social contract, the rights that you get by agreeing by, as one of the panelists said, by playing by the rules, we get to tell you what the rules are because you already showed that you can't follow the rules. One of the things that you do retain no matter what, and this is something that comes from the Magna Carta days, is going to be the right to challenge your detainment through habeas corpus, and then to also, as a collateral attack on your conviction, through post-conviction relief, a legal sentence, post-conviction DNA testing, but those are, again, legislative graces. And those are going to be things that the legislature and the Florida Bar, through its Rules Committee, can propose to the Florida Supreme Court to adopt as a substantive rules. This isn't just about statutes. This is also about the rules of court and the administrative procedure that you have through the Department of Corrections. If you have an issue within the Department of Corrections, you cannot just go to the court. 9 times out of 10, you actually have to exhaust your administrative remedies through the Department of Corrections. And if then it's not satisfactory, you may then file a petition in the circuit court in which you're housed, and then eventually seek appellate review of it. But you don't have many opportunities or rights. You do have at least something in terms of the rights to the courts.
I'll talk about just a little bit some of the rights that are retained as well as lost once they're actually inside of custody. And I'll just start, for example, with, as I look around the audience here, I see everyone here has their hair shaped and styled in a specific manner, which is fine right now. If you come to jail, that's still applicable. However, as mentioned, if you're sentenced and you transition to DOC, then modifications are made. Something basic like that is a right they retain. Our guys also retain the right to practice their religious beliefs while in jails too as well as something as simply as clothing that they wear, marriage, they still have opportunities to vote while also incarcerated for those that still apply. And those are just some of the basic rights. So again, as mentioned earlier, some of the rights are not necessarily lost, but some of the rights are you're not able to exercise while you're in custody, but there's some you are exercising. And keep in mind, I work in a county jail, so a significant portion of our population is pre-sentenced. So they haven't lost some of those rights yet. So I think collectively what both of us are saying is that the rights, they still maintain some, but some of them are lost depending upon what stage of the criminal justice system that you're currently in.
Do we have any more questions from the audience?
Thank you, appreciate it. First off, you all did a wonderful job. So I wanted to commend you all on, the good job that you guys did. So when a person gets incarcerated, they go through an orientation process. They're informed of the policies and procedures of the jail and things that they have to follow. But once they get released, is there like a mechanism in place for them to receive this wonderful education that you guys provided? Like information on their rights being restored or anything of that nature?
Yeah, one of the things that we've seen with this coalition growing is that there really has been such a lack of resources across the state. But on our website, we've started to create a resource page which showcases all of the different organizations in the state which do anything related to reentry or mass incarceration that may prove useful for somebody getting released. And we've also put together a map that allows somebody to select, which prison, like they push a button and all the prisons in the state pop up. They can push the second button, which is colleges, and all the colleges will pop up, and they can see in proximity to where they are, which organizations are near them, and which colleges are near them, which universities are near them, which prisons have educational programs. So we're really hoping to broadcast that availability to as many people as possible when they're released. And we also have a page which gives really, really large PDF files of how to get connected to transportation services, how to get connected to reentry services, the details of the ins and outs of the process of reentry and how to best navigate that system. But, there is so much difficulty with even knowing that FCHEP exists. And so it's been a really awesome thing when we get contacted by somebody who wants what we have, and we're able to let them know what is available to them, and we encourage them to share it with as many people as possible. But it's growing every day, but we're really happy that we have that available for the folks that are out, or getting out.
I was just going to say, I feel like it's the not-for-profits or organizations, community organizations that offer that, which still requires someone to find it. And obviously, a lot of the organizations have outreach because they understand that gap. But there's nothing official, and I think the rule of thumb, and Malik, correct me if I'm wrong, you get $20 when you're released from DOC, do you know?
I can't remember the dollar amount.
Something.
I want to say 100 now.
Oh,
Yeah.
fancy. I was a
Yeah,
member. I also don't want to put on record how long though, as a public defender, but you get some sort of like cash, I think, basically, in a bus pass to somewhere in Florida. So I had many clients who were arrested just in that process because something would happen and they would be stuck somewhere and literally have no one, not have any resources, and just end up violating probation, typically, for various things. And so when I said people, the most common way for people to contact me and learn that they have their rights restored is they contact me for clemency. As an attorney, they want to hire someone for clemency purposes, which I actually don't take those cases because currently it takes maybe on average 12 to 15 years for your case to be addressed, if it ever is, which can change, because it's based on the governor's office and their policies. But so I don't want to take someone's money for something that won't ever happen. But in those conversations, I typically ask, well, why? Like, what are you specifically interested in? And that will often lead to, well, I want to be able to vote. And I'll say, well, let's see if you already can. About 80% of the time they actually could, and they didn't know. And that's just because they wanted to pay me to do something that I didn't even need to do for them. So I definitely know that there's a disconnect of information, of people not knowing not only what their rights are, but what resources are available to them.
I think we had one more question while we're in the back row.
I had a question about the people incarcerated. I wanted to know, is it a violation of felon rights when those incarcerated, the privatized prisons, are allowed to exploit those prisoners for labor, for companies that are made to profit off them? Because not a lot of people know this, but there are several states like New York, Louisiana, I don't know about Florida, but the privatized prisons, they like to use those prisoners, those incarcerated, to use them to make things, use them for labor, basically do simple things in prison. And they don't like to pay them that much of the money that they usually make the people outside do it. Like they were paying like 30 cents or 25 cents. And that's barely enough to live, let them live inside, especially when people have to send money to those inside. So I want to know, is that a violation of felon rights when those privatized prisons do that?
I'm not an expert on that. I'm sure the other panelists have some great insights, but it is not a violation of their rights in terms of what is allowed to happen. And I think what it shows is the broader view that companies and corporations, how they view people. And what we're seeing is it's not just in the prisons, but even in the outside world. It's how much can we charge folks before they revolt? How little can we pay them before they revolt? How far can we exploit these people before we get any pushback? And it seems that they're able to do whatever they want, and the pushback that we are able to provide has little to no effect on their actions. And as the government becomes more corporatized, I hate to say it seems like it's going to continue to happen that way and maybe even get worse. But through things like this, we may be able to expose how harsh that is. But I'm sure the panelists may also be able to touch on, the 13th and 14th Amendment, and I won't say too much, but I'll pass it to the other panelists. I think they can do a better job than me.
So the 13th Amendment is part of that conversation. Of course, the 13th Amendment comes from the historical aspect of indentured servitude, which was to have somebody exchange, being able to come to the colonies, for example, in exchange they owned you. And we also saw that with slavery. So the purpose of our 13th and 14th Amendments were part of what we had from Reconstruction for it. Where the 13th Amendment comes in on this is that in Florida, it's like $50 a day that you get charged for being incarcerated. That is a cost you have to pay. If you have a mandatory sentence for a firearm conviction of 20 years, I went to law school to avoid math, but 20 times 365 times 50, I think would be a really high number. When you are paid very low wages, cents on the dollar for it, there is no way that you're ever going to make a meaningful amount of money from your labor. And at what point in the jurisprudence does that become a form of indentured servitude? You get into the 14th Amendment for it, and the 14th Amendment is the incorporation of those rights to the state. So the federal constitution is a TLDR, federal constitution applies to the federal government, but the rights that we have individually gets incorporated through the 14th Amendment for it. And with the 14th Amendment, if you have it saying we can't have, if you can't have indentured servitude, you can't have slavery, how do you then turn around and justify and say, well, because these people are a different class of people, we can charge them $50 a day, pay them $2 a day, and say that we're somehow square for doing this for it. That is something that you'll see very frequently. The ACLU, for example, is an organization at the federal level. Because it is a federal constitutional issue, that's where you're going to see these organizations for it. I just actually looked up an ACLU report on it, and you'll see that these programs are everything. Like, we're talking like major brands that you've heard of. For example, there are instances in which state agencies are utilizing them for janitorial services because, again, it's a resource of labor for it. But as to the yes, there is absolutely a constitutional tension that is there, but it has not matriculated to the point of getting before the United States Supreme Court because of the restrictions. And one of the issues that you have and why it takes so long is the United States Supreme Court is a court of very, very narrow jurisdiction. I mean, it's like trying to thread the eye of a needle with your eyes closed with no hands. And with that being said, in order to get these major constitutional questions, it takes years, if not decades, for them to go through the process to be heard before it. And until you have a decision from the United States Supreme Court that affirmatively holds this right applies in this manner, it's largely left to your state courts and your various federal courts to interpret those matters.
I was going to say our facility, we don't pay inmates in the physical sense to do work, but we do utilize them throughout the compound. So for example, they do inmate laundry, they prepare their food, they maintain the grounds and yards. And what happens for them, their incentive is they get statutory gain time for working for us. So by you becoming an inmate worker, the term that we use, it allows you to get out of jail sooner. I can't force you to work if you're pre-sentenced. If you're a pre-sentenced inmate, I can't force you to work. But if you've already been adjudicated as guilty and you're sentenced, and I assign you a job and you don't want to work, then now I can take disciplinary action because you're already sentenced. That ties in with the 13th and 14th that was just talked about. But again, we have an abundance of guys that are wanting to work and go out and maintain the grounds and go to the kitchen and cook. And that way they're not sitting in that cell 24 hours a day. They'll volunteer to get that additional gain time. Now on the flip side of that, I've toured facilities where inmates are given $1 an hour to work. I've been in facilities like that where inmates earn a wage. I've also toured a facility where an inmate can earn a flat $75 a month for working. So again, it just depends on where you're at, but I can share with you that we don't do that. And piggyback also off of the subsistence fee, the cost of incarceration is very high. So you'll see jails now referred to as a subsistence fee. And that means while you're incarcerated, you pay a flat dollar amount to be incarcerated. Part of that is a dollar amount you pay to be booked into the jail. You may have to pay for medical services, things of that nature. And all those fees and things like that offset the cost of incarceration.
I want to thank our panelists. Thank you to the audience for these excellent questions, and thank you for sharing the diverse and substantive perspectives on these complex policy issues. Today you've heard viewpoints ranging from those emphasizing public safety, accountability, and those highlighting rehabilitation and reintegration, from constitutional interpretation to sociological research, from the courtroom realities to correctional practices to lived experiences navigating these systems. The issues we've discussed, voting rights, employment rights, educational access, financial obligations, and the fundamental question of what rights can or should be restricted following a criminal conviction, are actively debated in Florida's legislature, courts, and the communities. These are not settled questions with single correct answers, but ongoing policy disputes requiring informed citizens to weigh competing values, empirical evidence, and constitutional principles. As you leave, I encourage you to continue exploring these questions, review the statutes we referenced today, thank you so much, read the research on recidivism and reintegration, speak with people directly impacted by these policies, and engage in the civic process, whether through voting, advocacy, or community service. A video of today's recording is going to be posted on the Office of Public Policy Events website and will remain publicly accessible. We encourage you to share it with others who may benefit from hearing these diverse perspectives. Thank you for attending today, and please join us in thanking our panelists once more.